We're back. A procedure under mortgage on default. Causes for seizure by mortgagee. 21. Unless it is otherwise specially provided therein, goods and chattels assigned under a mortgage or conveyance intended to operate as a mortgage of goods and chattels shall be liable to be seized or taken possession of by the grantee for any of the following causes. 1. If the grantor shall make default in payment of the sum or sums of money thereby secured at the time therein provided for payment or in the performance of any covenant or agreement contained in the mortgage or conveyance intended to operate as a mortgage or necessary for maintaining the security. 2. If the grantor shall, without the written permission of the grantee, either remove or suffer the goods or any of them to be removed from the registration district within which they are situate. 3. If the grantor shall suffer the said goods or any of them to be distrained for rent, relates, or taxes, or shall suffer the said goods or any of them to be liable to seizure for rent by reason of default of the grantor in paying the same when due. 4. If execution shall have been levied against the goods of the grantor under any judgment at law. 5. If the grantor shall attempt to sell or dispose of or in any way part with the possession of the said goods. And this is a new section. Renewal of mortgages, not valid unless renewed. 22. Every mortgage or conveyance intended to operate as a mortgage filed in pursuance of this act shall cease to be valid as against the creditors of the persons making the same and against subsequent purchasers or mortgages in good faith for valuable consideration after expiration of 2 years from the filing thereof, unless within 30 days next preceding the expiration of the said term of 2 years, a statement exhibiting the interest of the mortgagee, his executor, administrators, or assigns in the property claimed by virtue thereof, and a full statement of the amount still due for principal and interest thereon, and of all payments made on account thereof, is filed in the office of the registration clerk of the district where the mortgage is filed, with an affidavit of the mortgagee or of one of the several mortgagees or of the assignees or one of the several assignees or of the agent of the mortgagee or assignee or mortgagees or assignees duly authorized for that purpose, as the case may be, stating that such statement are true and that the said mortgage or conveyance has not been kept on foot for any fraudulent purpose, which statement and affidavit shall be deemed one instrument. And then they have here a statement and affidavit. I won't give you that. I won't read that. You'll have to get your own, or you'll have to come here to get that. I'm not going to put that. That's like, the affidavit is already written for you. 24. So we're skipping 23. We're going to 24. Further renewal yearly. Another statement in the form provided in section 23, duly verified as required by that section, shall be filed in the office of the registration clerk of the district where the mortgage is filed within 30 days next proceeding. The expiration of the term of 1 year from the date of filing the statement required by section 22, and in default thereof, such mortgage shall cease to be valid as against the creditors of the person making the same, and as against purchasers and mortgagees in good faith for valuable consideration, and so on from year to year. That is to say, another statement as foresaid, duly verified, shall be filed within 30 days next proceeding the expiration of 1 year from the date of the following of the former statement, and in default thereof such mortgage shall cease to be valid as foresaid. Registration of statement and affidavit. 25. Where there has been a permanent removal of the goods and chattels as mentioned in section 35, and a certified copy of the mortgage has been registered as required by that section, the statement and affidavit mentioned in section 22, 23, and 23 shall be registered in the office in which such certified copy is registered. And the period of 2 years mentioned in section 22 and of 1 year mentioned in section 4 shall be reckoned from the date of the registration of such certified copy. By whom affidavit made. 26. The affidavit required by section 23 may be made by any next of kin, executor, or administrator of any deceased mortgagee, or by an assignee claiming by or through any mortgagee or any next of kin, executor, or administrator of any such assignee. But if the affidavit is made by any assignee, next of kin, executor, administrator of any such assignee, the assignment or the several assignments through which such assignee claims shall be filed in the office in which the mortgage is originally filed, at or before the time of the filing of such affidavit by such assignee, next of kin, executor, or administrator of such assignee. Agent's authority to take conveyance. Authority may be general. 27. An authority for the purpose of taking or renewing a mortgage or conveyance intended to operate as a mortgage or sale, assignment, or transfer of goods and chattels, book debts, accounts, and debts to be incurred under the provisions of this act may be a general one to take and renew all or any mortgages or conveyance to the mortgagee or borrower, and provided such general authority is duly filed with the clerk, it shall not be necessary to attach a copy thereof to any mortgage filed. Affidavit by company officer. 28. In the case of a mortgage or sale of goods, or in case of a sale, assignment, or transfer of book debts, accounts, or debts to be incurred to a corporation, the affidavit of bona fides required by this act, and the affidavit required upon the renewal of a chattel mortgage may be made and the certificate of discharge or partial discharge of any such mortgage may be signed by the president, vice president, manager, assistant manager, secretary, or treasurer of such corporation, or by any other officer or agent of the corporation duly authorized by a resolution of the directors in that behalf, or if the head office of the corporation is outside Saskatchewan, then the said affidavit may be made by any general or local manager, secretary, or agent of the corporation within Saskatchewan. Any such certificate so signed shall be a valid and effective discharge or partial discharge without the seal of the said corporation being affixed thereto. Any such affidavit by an officer or agent shall state that the deponent is aware of the circumstances connected with the sale or mortgage, as the case may be, and has a personal knowledge of the fact disposed to. Omission and errors. Rectification 29. Subject to the rights of third persons accrued by reason of such omissions as are hereinafter defined, any judge of the Court of King's Bench or of the District Court of the Judicial District within which such goods and chattels are situate, on being satisfied that the omission to register a mortgage or other transfer of personal property or any authority to take or renew the same or any statement and affidavit of renewal thereof within the time prescribed by this act, or the omission or restatement of the name, residence, or occupation of any person was accidental or due to inadvertence and impossibility in fact, may in his discretion order such omission or misstatement to be rectified by the insertion of the register of the true name, residence, or occupation, or by extending the time for which registration on such terms and conditions, if any, as to security notice by advertisement or otherwise, or as to any other matter as he thinks fit to direct. Assignment of mortgages. Filing 30. In case any registered chattel mortgage has been assigned, such assignment may, upon proof by the affidavit of a subscribing witness, be numbered and entered in the book mentioned in section 29 in the same manner as a chattel mortgage, and the proceedings authorized by section 32 and 33 of this act may and shall be had upon the certificate of the assignee proved in manner foresaid. Discharge of mortgage. This is what you want to know, how to discharge. Discharge of mortgage. Discharge. 31. When any mortgage of goods and chattels is registered under the provisions of this act, such mortgage may be discharged by the following in the office in which the same is registered, as a certificate signed by the mortgagee, his executor, or administrators. See Form B. Entry and endorsement 32. The officer with whom such chattel mortgage is filed upon receiving such certificate duly proved by the affidavit of a subscribing witness, shall at each place where the number of such mortgage has been entered with the name of any of the parties thereto in the book kept under section 19, and wherever otherwise in the said book the said mortgage has been entered, write the word discharged by certificate number, stating the number of certificate. And he shall also endorse the fact of such discharge upon the instrument discharge, and shall affix his name to such endorsement certificate. Any person following a discharge of mortgage or a partial discharge of mortgage, as foresaid, shall be entitled to ask for and receive from such clerk a certificate other than the certificate which might be endorsed on a copy or duplicate of the mortgage as foresaid, of such discharge or partial discharge in the form following or to the like effect. And they have a letter. I know you see it, but I won't read it. You're going to have to come get it yourself, or however you get it. Chattel mortgages, removal of chattel mortgaged. Mortgage goods not removed without notice. 34.1. No goods or chattels under mortgage shall be removed into another registration district without a notice of the intention to remove being mailed, post, paid, and registered not to the mortgagee at his last known place of address not less than 30 days prior to such removal. 2. Any person violating this section shall be liable to the penalties not exceeding $100. Removal of another district. 35.1. In the event of the permanent removal of goods and chattels mortgaged as foresaid from the registration district in which they were at the time of the execution of the mortgage to another registration district before the payment and discharge of the mortgage, a certified copy of such mortgage under the hand of the registration clerk in whose office it was first registered, and of the affidavit and documents and instruments relating thereto filed in such office shall be filed with the registration clerk of the district to which such goods and chattels are removed within 3 weeks from the removal. Otherwise, the said goods and chattels shall be liable to seizure and sale under execution, and in such case the mortgage shall be null and void as against subsequent purchasers, and mortgage is in good faith for valuable consideration as if never executed. Removal of Saskatchewan, removal into. 2. In the event of the permanent removal into Saskatchewan, the goods and chattels subject to the mortgage or bill of sale made, executed, or created within Saskatchewan from a place in which they were at the time of the execution of said mortgage or bill of sales, a copy thereof, and of the affidavit and documents and instruments relating thereto, provided to be a true copy by the affidavit of some person who has compared the same with the originals, shall be filed with the registration clerk of the district to which such goods and chattels are removed within 3 weeks from such removal. Otherwise, the mortgagee or bargainee shall not be permitted to set up any right of property or right of possession to said goods and chattel against the creditors of the mortgagor or bargainer, or against subsequent purchasers or mortgagees in good faith for valuable consideration, evidence, certified copies. 36. Copies of any instrument filed under this act certified by the registration clerk or the registrar of joint stock companies shall be received as prima facie evidence for all purposes as if the original instrument was produced, and also as prima facie evidence of the execution of the original instrument according to the purport of such copy, and the clerk's or registrar's certificate shall also be prima facie evidence of the date and hour of registration and filing. It says affidavits, oaths, 37.1. All affidavits and affirmations required by this act may be taken or administered by the registration clerk or his deputy or any person, whether in or out of Saskatchewan, authorized to administer oaths or take affidavits for use in Saskatchewan, and a sum of 25 cents shall be payable for every oath thus administered. 2. When a document has been executed by a corporation under the provisions of this act, no affidavit of attestation or execution shall be required to accompany such document for the purpose of registration. Expiry on holiday of time for a following. Expiry on Sunday or holiday. 38. Where under any provisions of this act, the time for registering or filing any mortgage, bill of sale, instrument, document, affidavit, or other paper expires on a Sunday or other day on which the office in which the registering or following is to be made or done is closed by reason thereof the following and registering cannot be made or done on that date, the registering or filing shall be so far as regards the time of doing or making the same be held to be duly done or made, if done or made on the day on which the office shall next be opened. Clerk's fees. 39. For services under this act, each registration clerk shall be entitled to receive the following fees. 1. For each following, including stamping, duplicate, original, if any, with registration stamp, 50 cents. 2. For following each assignment, renewal statement or certificate of discharge, and for making all proper endorsements in connection therewith, 50 cents. 3. For searching each name, 50 cents. For each certificate or abstract of search, 25 cents. For each certificate under section 31, 50 cents. For copies of any document filed under this act, with certificate thereof, every 100 words, 10 cents. Railway equipment, 40. In the case of a bill of sale or of a mortgage or conveyance for the purpose of securing bonds or debentures made by an incorporated company of cars, equipment, rolling stock, and other chattel property owned by it, it shall be sufficient for the purpose of this act if the bill of sale, mortgage, or conveyance, or a notarial copy thereof be filed in that office of the registrar of joint stock companies within the time limited by this act for filing chattel mortgages. Such bills of sale, mortgage, or conveyance shall have priority from the date of filing, and such mortgage or conveyance shall remain in force without the necessity of renewal or of any affidavit of execution or bona fides until the same has been discharged and satisfied, and discharge of such mortgage or conveyance may be registered in such office. And then they have these forms. You see this one, but you won't see the other one. Mortgage of chattel, discharge of chattel mortgage. You can go get the book and get it. I mean, I don't want to put everything out here. And I'm not going to read that. It's more, And that reading was the Chattel Mortgage Act, Chapter 200 of the Revised Statutes of Saskatchewan, 1920, assented to November 10th, 1920.